and its defense motion for post-trial bond. Mr. Green, do you want to start?
Your Honor, if I could, what I had arranged with Mr. Claypool is he might make an opening statement, and then if we could, we would ask the court to call Mr. Dippolito's mother to establish her local ties to the community. The court is amenable to that.
That's fine. Go ahead, Mr. Claypool.
Yeah, thank you, Your Honor. I just have a few points in case you lose me on the phone. First of all, I appreciate the court's accommodation to allow me to appear by phone on a child care issue this week. In terms of the motion for bond, I just want to respectfully remind the court that the purpose of bail is to ensure the accused's attendance at a hearing. It's not to punish or further punish the defendant. That's not the point of granting bond in this case. And I think that nothing speaks volumes more than the past 8+ years with Dalia Dippolito. She has fulfilled the spirit of what bond is. She has been a model inmate for 8+ years on house arrest. The only minor infraction, Your Honor, that surfaced over the past 8 years was actually my fault. If you recall, that was during an interview that was conducted, I believe, by 2020, and I had given her improper advice on where she could walk along the sidewalk. So that's my doing. Other than that small infraction, she has been a model, and she has appeared at every single hearing, and that has not been an issue at all. The second point I'd like to raise before I get into the merits of the appeal, although the court does have broad discretion on granting bond, the Florida courts have made it clear that that's not without limitation. And what I mean by that, Your Honor, respectfully, is that the court cannot act arbitrarily, or rule arbitrarily, or rule capriciously, or rule in a way that might be consistent with how Your Honor has ruled on our motion for a new trial. There has to be some rationale in the court's decision on whether to grant bond or not. It's not an unfettered right or a discretionary right on the court's part. With that said, briefly, I'd like to discuss the factors that the state mentioned in the Youngins factors. I would argue, Your Honor, that 3 of those 4 factors support the court granting bond for Dalia Dippolito. The first factor that the state mentioned was, they said, well, Dalia Dippolito lost the first trial, and then there was a hung jury in the second trial, and the state won the third trial. Therefore, the court shouldn't grant bond because it's likely she's going to lose if there was a 4th trial. What I'd like the court to do is to respectfully take a closer look at that first trial and consider that. For purposes of this analysis only, it will be our position that right now we're on an equal, fair playing field. That first trial was reversed because of the trial judge having conducted improper voir dire of the jury, didn't do an individual voir dire of the jury, such that a disparaging comment made by a prospective juror poisoned the entire jury pool. So it's our position in this hearing that that first verdict was poisoned or toxic and should not be considered a flat-out victory for the state. That first trial that this court had without a jury that had been contaminated, we actually obtained a hung jury, and I know that we mentioned 3-3 was the verdict, or the jury count in that second trial. It was actually the alternate jurors in that second trial had voted in our favor as well. So we had actually secured 5 votes of the jury in the second trial, and then the state's correct. And in the third trial, the state did prevail. But it's our position that if you eliminate that first contaminated trial, right now we're at 1-1, and who knows where things would go if there would be another trial. So that first factor, I think, does still gravitate in our favor. The second factor I would concede to the state. The state makes an argument, well, she's been sentenced to 16 years, that's a lengthy sentence, and therefore she should be granted bond. If you take that factor alone, the state's got a great argument. We do agree that's a long sentence that the court has given to Ms. Dippolito, but that factor in and of itself is not going to be dispositive in Your Honor's ruling. I think when we get to the factors 3 and 4, this is where I think we have really solid argument for the court granting bond. The third factor that the state mentions is does Dalia Dippolito have any meritorious claims for appeal? And the Florida courts have made it clear that the measuring stick for that is not, are we going to prevail? Is there a good chance we're going to prevail? But the fact, or the measuring stick, Your Honor, is it is fairly debatable that Dalia Dippolito has a shot on appeal. And for the court's edification, I'm sure you're aware we have filed a notice of appeal. And, it's our position categorically that, there are 3 major issues that we will be pursuing on appeal, and I'm saying this respectfully because it is a bit awkward because Your Honor's already ruled against us on a new trial based on these factors, but I want to go ahead and mention these factors for Your Honor. The first one was the court admitting evidence of the allegation that Dalia Dippolito attempted to kill Mike Dippolito by using antifreeze, I believe, in a cup of tea. And it's important to note that both in the first trial, the trial judge in that case did not allow that evidence to be presented to the jury. I believe he ruled that it would be very inflammatory under Rule 403. And then in the last trial that we did, so it'd be the third trial that we've done in this case, there was a pretrial ruling, and I believe the state had even stipulated that evidence would not come into trial in the last trial. And it wasn't until the last day of trial where the state came up and said, well, we want to try to get this into evidence as impeachment. The court did an offer of proof, and I believe that the offer of proof was a confidential informant, Mohammed Shahade. It's our position, Your Honor, and we'll take this position on appeal, that what Shahade said in the offer of proof actually validated that it wasn't really true impeachment evidence. It's our position that what he was saying on the stand didn't really contradict something that he previously said. With that said, we won't spend a lot of time on that. Let's move to the more profound argument, which is we can debate all day whether that was truly impeachment evidence on the antifreeze allegation. But the more important point, we made vigorous argument in trial about this, was the 403 issue, which is what is the profound prejudicial effect on the jury going to be when you weigh it against the probative value of that evidence. And it's our position that a jury hearing about Dalia Dippolito allegedly trying to kill Mike Dippolito with antifreeze was a death nail. It was a death sentence in that third trial. So the prejudicial effect of that evidence clearly outweighed the probative value. That's the first major hell issue that we're going to be raising. The second one was that issue, Your Honor, I'm sure you recall, the Riviera Beach evidence that came in. Again, for the record, I can't recall whether the state stipulated to that not coming in, but I know there was a pretrial in limine order that Your Honor had signed indicating that it wasn't going to be coming into evidence in the third trial. I don't believe the Riviera Beach, what I mean by Riviera Beach was the allegation that Mohammed Shahade has spoken to somebody who had overheard Dalia Dippolito allegedly trying to hire a hitman with the name Larry, which he used to try to kill Mike Dippolito. I don't believe that evidence was even permitted in the first trial in which Dalia Dippolito was convicted. Be that as it may, in the third trial, up until the last day of trial, that evidence was not permitted to be discussed in front of the jury as well. The state then came forward and said, hey, wait, we're trying to use this as impeachment evidence again against Mohammed Shahade. We did an offer of proof on the Riviera Beach allegation. It's our position on appeal that not only were there several layers of hearsay, but it just wasn't reliable enough. There are a couple things. It wasn't reliable enough, and that's one of the factors Florida courts look at. Is this evidence? I guess the state was trying to use to show propensity for Dalia to want to try to kill her husband, but there still has to be a reliable foundation for that evidence. And I believe, Your Honor, if you recall, Muhammad Shahadi even said at one point, hey, this is street information, and street information is often unreliable. I believe he said that in the offer of proof. So it's our position that even if this wasn't true impeachment evidence of Muhammad Shahadi with respect to the Riviera Beach allegation, but even if there is a determination that the allegation of the Riviera Beach incident was impeachment, that again, the prejudicial effect of a jury hearing that Muhammad heard somebody else say that Dalia was trying to hire a hitman to kill her husband. Again, that is going to be an absolute death nail in the trial. The jury is not going to be able to get beyond hearing that evidence to hear the other evidence in the case that we were making about a police investigation that lacked integrity. The third appellate issue that we'll be raising, Your Honor, and we've already raised this before, Your Honor, is the allegation of one of the jurors sleeping during critical evidence during the trial. I'm not going to debate the entire issue again. I'm just going to, the only point I'd like to make is since I've last seen you, a member of the jury panel had come forward. So again, it wasn't just affidavits that we had submitted from folks in the courtroom, in other words, observers in the courtroom. We now have, I believe it was an audio tape or videotaped interview with a reporter named Michelle Casada, in which this juror said, yeah, I did notice one of the jurors nodding off, and her eyes were closed, and that I believe a couple of alternate jurors had actually wake up the woman later named Castaneda, the juror, during parts of the trial. So the court, I believe there may be a motion pending on the recent developments with one of the jurors coming forward. Putting that aside, we believe that is a meritorious appellate issue. Not only does the Constitution, the Sixth Amendment affords a defendant a right to a fair trial, hearing all the evidence, I believe there's case law in Florida too that suggests that if a juror is not hearing or not paying attention, critical evidence in the case, that is depriving a defendant of a fair trial. So those are three issues you're going to raise in an appeal. Well, why are they important in the scheme of things for this bond hearing? Well, the state has proffered to Your Honors that this case is much like the Goodman case. I'm sure the court's aware of that case. And in the Goodman case, they parallel Dalia Dippolito Goodman. They say, well, look at what the judge did in Goodman. He did not grant bond after the second trial. Now, a couple differences in Goodman versus Dippolito, Your Honor. One of them I just mentioned. That's why it's important to make that distinction. In Goodman, there really was no legitimate issue on appeal. There really was nothing meritorious that Goodman could raise on appeal. And fast forward to this case, Your Honor, it's not as if we're going up on appeal in this case, for example, on improper jury selection, because I think Your Honor did a fantastic job in both the trials that I conducted in selecting the jury. So we're not trying to, cover our eyes and put our hand in a hat and pull out, oh, jury selection, bad jury selection. Let's appeal that while we can get Dalia bond. We're not doing something like that because the judge did a great job at jury selection. What we're saying is there are three bona fide issues that I've just outlined that I'm not telling you whether we're going to win or not. We're hopeful, obviously. We will, but we think we have a reasonable, at least minimally, a fairly debatable chance at winning on one or more of those appellate issues. So this is not like the Goodman case on the appellate issues in Goodman. And then the final factor I'm going to mention, Your Honor, does dovetail the Goodman argument again. In other words, the state mentions Goodman and says do what they did in Goodman, don't grant bond. But the other difference, and here I'm getting to my fourth factor, is flight risk. That's another factor that the state mentioned, the factor that's considered by Florida courts. So was John Goodman a flight risk versus Dalia Dippolito? I mean, the trial judge, I think Mr. Williams had a task order from the trial judge in the Goodman case. He flat out said, hey, Goodman's got a lot of money. He's affluent. He also has family members who are affluent. He has the means to flee, the financial means to flee. That's a really profound distinction, Your Honor, from the Dalia Dippolito case. She's already been deemed by the court indigent. She has very little money. I haven't been paid. Her lawyers haven't been paid on this case. So she does not have the financial means to flee. More importantly, she surrendered her passport. And what better metrics for Your Honor to look at? Forget about everything I'm saying, or what Mr. Williams is going to say, or what Mr. Greenlee is going to say. Forget about that. Look at her behavior over the past 8 years, Your Honor. If she was a flight risk, she would have done something over the past 8 years in trying to flee. She now has, and I know Your Honor's already mentioned you can't, consider her child. I know you could consider her child in the sentencing hearing. I get that. But that it is important and relevant for the bond hearing from the standpoint of another issue the courts look at, which is, does she have any family ties in the community? And clearly, Dalia Dippolito's entire lifeline is in South Florida. Not only is she very close to her mom and her younger sister, but her child. And we're not playing up the child card here, Your Honor, to try to get sympathy for Dalia Dippolito. It's important to look at it from a legal standpoint, which is she has unwavering ties to that community. So for her to try to flee and leave the country and leave everything she's living for and breathing for, it is completely at odds with common sense. So please consider that as well, Your Honor. And then the last point I'm going to make on this analysis is everybody's aware the state has brought up this issue of a jailhouse phone call, and it's arguably important from the standpoint of flight risk. That's the last factor we're talking about right now. Yeah, so the state brought it up and said, well, listen to this phone call. This proves that Dalia Dippolito is a flight risk, and I would argue that I'm sure Your Honor has listened to the phone call as opposed to just reading, the written transcript that Mr. Williams attached. And I think when you take a look at the entire 10-minute phone call and look at the full context of that jailhouse phone call, this was not Dalia Dippolito trying to orchestrate some fantastic plan to try to escape from jail. Granted, Your Honor, it was not smart of her to make a comment like that on a jailhouse phone call, knowing that call is going to be recorded. But I'll give the court and the state that concession. But realistically, you hear that whole phone call. I mean, it was the first few minutes. Dalia was talking about loving her child, loving her family, wanting to do some speaking. She didn't call up this guy James and say, hey, dude, I got a great plan. I just read this article. Let's do it. There's nothing in that phone call, Your Honor, where Ms. Dippolito is requesting or seeking. As the state said, she was enthusiastically trying to get this guy James to do something. That, respectfully, Your Honor, is not the truth if you listen to that phone call. There was nothing enthusiastic in Dalia Dippolito's voice. It was very monotone. The entire conversation, to me, sounded like it was later at night. Two people that sounded tired, especially this James guy. And Dalia Dippolito had a similar tone of voice pretty much throughout the entire phone call. And another important point about the phone call, Your Honor, there were gaps during the phone call. In other words, there would be a discussion, then there would be silence during the phone call. It almost struck me as if these two were strained to carry on a conversation. Because there was a break in the call, and then Dalia Dippolito says, randomly, I heard about this inmate in South Carolina escaping using a drum. So she just came, it was a disconnect. And then she mentioned that this guy James kind of said something about, well, it could happen or something to that effect. And then Dalia Dippolito could say, yeah, that sounds great. Let's get on it. Get me some wire cutters. She didn't say anything to that effect at all. And I think, look, that she said, settle down. So, and then after that, your last point I want to make about this jailhouse phone call is after they had this short discussion, 10-minute phone call, maybe 45 seconds to a minute, they're talking about this South Carolina inmate. Then there's another gap in the phone discussion. And then they're talking about this guy James and his mom and church. And then she finishes the phone call by saying that Dalia is heading out to meet some women to read as part of his, I believe, a reading club that she was involved in. So I think when you look at the entire context of that 10-minute phone call, I trust the court's judgment in reaching a determination that that jailhouse phone call does not indicate that Dalia Dippolito is a flight risk. And if the court makes that determination, and you look at the four factors I just discussed, combined with the 8+ years of good behavior by Dalia Dippolito on house arrest, I would ask that the court grant a modest bond in this case. Thank you, Your Honor. And I'd like to ask, Your Honor, at this time, as the court is inclined to have a hearing and make a ruling on the second motion for sanctions against my co-counsel, I wanted to address that briefly if the court's inclined to do that or to defer hearing that until Mr. Rosenfeld is back in town.
I'm not hearing that today. Mr. Rosenfeld would have to be here.
Right, that's what I thought.
So that will
Okay.
be started off at a later time.
All right, thank you for your time, Your Honor.
Okay. All right, Mr. Greenlee, did you want to call the witnesses?
Yes, Your Honor, please support on that. Call Dalia's mother.
Sorry.
Your Honor, I appreciate it.
I'm not going to have her take the stand. She'll just stand at the mic. Please raise your right hand for me. Do you swear or affirm the evidence you're about to hear is the truth, the whole truth, and nothing but the truth?
Yes, I am.
Put your hand down. First, please state your full name for me.
Rana Mohammed.
Okay. You may inquire.
Thank you, Your Honor. Ms. Mohammed, how do you know the defendant?
She's my daughter.
Where did your daughter live prior to being taken into custody?
With me.
What is your address?
8132 Eastern Harbor Circle, Golden Beach.
So that is within Palm Beach County.
Yes.
Does your daughter, Mr. Guido, have any family that lives here?
Yes, she does.
Could you describe the family ties to the community?
My son, his wife, his son, my youngest daughter, myself, and my brother.
Does, if you know, Mr. Guido have any religious, does Mr. Guido have any religious affiliation?
Yes, she does.
Does she attend services?
Yes, she does.
How often, if you know?
Twice a week.
Twice a week. How long, if you know, did Mr. Guido serve on house arrest?
8 years.
Did she ever express an interest in fleeing the jurisdiction of this court?
Not at all.
Over the past 8 years that Mr. Guido has been on house arrest, if you know, has she ever failed a random drug or alcohol test?
Not at all.
Has she paid the money that she owes on house arrest in a timely manner? You know?
Yes, she did.
If she's ever had an appointment on house arrest, do you know whether she has filled out the verification forms that were required for her
Yes, she did.
every time?
Yes, she did.
Has she ever been late coming home from any appointment?
No.
If you know, when visitors have knocked on the front door for random house arrest home visits, has she answered the door
Yes.
every time?
Yes.
When house arrest randomly calls her, does she pick up the phone?
Yes.
whenever house arrest has ordered her to visit the office of her house arrest, does Mr. Dippolito timely attend those visits?
Yes.
Does she leave immediately?
Yes.
Does Ms. Dippolito drive herself when she goes on appointments?
Yes, she does.
So she's unsupervised when she goes out in the community?
Yes.
Has Ms. Dippolito, if you know, ever received any type of speeding ticket or other infraction that would demonstrate disrespect for the rule of law?
No.
Has Ms. Dippolito ever performed any community services or outreach to the local community?
Yes, she has.
Could you describe those efforts?
In church, she has done quite few community helping on the services on Tuesdays. And she has also done some cooking for the homeless, for the Palm Beach, the park in Palm Beach.
Do you know how often she prepares food for the homeless?
She has done it a couple of times.
Do you know whether or not your daughter is a registered voter in the community?
If she is, I'm sorry.
If she is a registered voter in the community?
Yes, I think she is.
Do you know whether or not she voted in the past election?
No, she didn't.
In your view, Ms. Muhammad, is your daughter a danger to the community?
Not at all.
Do you believe your daughter to be a flight risk?
No.
Thank you, Your Honor. I have no further questions.
Cross-examination.
The James that communicates with her on the jail calls all the time, tell the judge his real name.
Yes. Rob,
Robert what?
I'm sorry.
Robert what?
Your Honor, we would object on relevance grounds. We don't believe that this is relevant. In addition, it would require Ms. to reveal the name of the father of her child. In fact, she would rather not disclose, and given the minimal relevance, we would object on it.
We didn't ask that question, just asked the person on the phone. What was the person's name on the phone? Since that's part of the state's presentation of the basis for denying bond, and what impact or effect he may have on conditions of appellate release or release on bond pending appeal, I'm going to overrule the objection.
Robert what?
Davis.
Davis. And does Mr. Davis have a criminal history?
I don't know.
You don't know. Okay. How long has Mr. Davis resided with you in your house?
A year. Something.
A year. Okay. And he's the father of the child?
Objection, Your Honor.
I'm going to sustain the objection that it doesn't matter for this hearing.
Were you aware back in 2009 of any of the plots your daughter was committing? Planting drugs, pretending to be doctors, lawyers, trying to have Mike Dippolito killed?
Objection, Your Honor. Her state of mind is irrelevant to the issues.
Overruled because she's testified now based on direct examination that she's not a flight risk, and to her character, the question becomes, what was her knowledge at the time? So I'm overruled the objection.
Were you aware of any of that? In fact, when your daughter called you from jail and you saw on the news what was going on, did your daughter lie to you about what she had done?
No, she didn't lie.
She didn't lie to you. But so telling you she did nothing wrong, you thought that was truthful?
Yes.
You did? Okay, so you've seen all the evidence and you still think your daughter did nothing wrong?
That's not how it happens. That's not how you're projecting it different, but you really don't know her.
Okay. Did you listen to you went to the trial, right? Did you hear your daughter's own words? You listened to the evidence?
Yes, I
And you believe she's telling you the truth that she did nothing wrong?
It's not the way they say it, yes.
So you believe that?
That's the answer, Your Honor.
Call roll.
That's all I'm asking.
Redirect.
We have nothing further.
Okay, Pam, you may sit down. Any additional witnesses that the defense wishes to call?
We have no additional witnesses, Your Honor. If I might just make one quick statement just to piggyback on something that Mr. Claypool said. Your Honor, I handled her case after her first appeal. The case is essentially in the same posture as after her first appeal, except the case provides even stronger now because Mr. Dippolito has demonstrated respect to the law enforcement over her 8 years in house arrest. And in addition, she is only facing 16 years of incarceration this time, whereas last time it was 20 years. So if anything, Your Honor, the case has only gotten stronger for appellate bond. If you're looking for an analogy as to the proper case, why not look to the exact case on the exact facts after her first trial, where she was granted an appellate bond? So, I mean, the analogy with Goodman, for the reasons that Mr. Claypool articulated, is flawed. The analogy to her case after her first trial is virtually identical. And Judge Colblatt, having reviewed the very same evidence that the state and the allegations are the same after her first trial. Nothing's changed, except for Mr. Polito's case has only got stronger. The issue of the first issue on appeal, Your Honor, is similar to the first issue on appeal. Not the same, but similar. And we would also respectfully point out that there are other issues of constitutional magnitude, including her due process right to present defense, which we submit was denied, as well as we believe that she was objectively entrapped as a matter of law. These are all issues of that are at least, Your Honor, fairly debatable. And with that, I would sit down. Thank you.
All right, let me hear from the state.
You saw our submission, you stand by it. I just didn't know if you had any questions about anything that came up.
No, I don't have any questions. I'm giving the opportunity to, for both sides to present any argument they wish to make. I mean, so if there's anything additional you want to add to the argument.
The only thing I would add, Judge, is that if you compare her and Mr. Goodman, and you look at the Youngins factors, because the respect for the law is a big issue in her case. We had Mr. Goodman, who's not out there using other people to commit serious felonies and try to have someone commit the ultimate crime for him for his benefit. He's in a non-intentional crime, DUI manslaughter, where here we have completely intentional acts. Flight risk about someone with money. All day long we sit here in the courtroom and it's not the people with money that are showing up, it's the people that don't have any resources and don't have any assets. They're the ones that flee. That's all day long. Of all the articles that she mentioned, she says she gets the paper at the jail, she reads the paper. Of all the ones that she decides to point out that piques her attention is the one about breaking out. The transcript doesn't tell the whole story. You listen to the tape,
I have the tape, I've listened to it.
Yeah, I mean, the tape absolutely is, I would say, the defendant wouldn't do anything deceitful, like plant illegal drugs on somebody, pretend to be a doctor or a lawyer, try to use him and deny being involved, using police officers to make up false allegations. She would never do anything deceitful. Not only is she a flight risk now, and the baby makes it even more of a flight risk. She has no ties to this community other than her family. Nothing. She loses nothing when she flees. She takes her baby and she's gone. But she's also a threat. Sitting in her house on house arrest prevents her from doing nothing. Her mind works in a different way. She manipulates and uses other people to carry out her deeds. Her sitting at home is the same thing as where she was back in 2009. So we're asking you, based on the Youngins factors, to deny her appellate bond.
Okay, technically the defense is the moving party. Any final words by defense? Mr. Graham?
Your Honor, just several. The allegations he raised, all were known to the court prior to her being given bond. None were charged, none were substantiated. We already established that she has strong ties to the community in addition to her family. Ms. Dippolito has informed me that a Detective Rodriguez, who works for the county jail, on Monday, who was assigned to investigate this jail call, has concluded that there was no evidence that she was flight risk. Mr. Dippolito has informed me that he would be willing to, or would like to inquire, be willing to come back to court. Unfortunately, I just learned that last night. I wasn't able to get him to come today. That Mr. Dippolito is correct. I mean, he listened to the call and he independently concluded that she did nothing wrong by mentioning this. Among the other topics on different days that Mr. Dippolito discussed, I won't go through all of them, but she wrote them down. Donald Trump and the Russian scandal. So that's one topic of development. North Korea launching missiles. Scaramucci is fired. All these on different dates. O.J. Simpson on parole. He's going to get out on parole after getting away with murder. The list goes on. Every day it's public current events. We would respectfully submit, Your Honor, that that's not evidence that she would talk about a highly publicized news article. It's, in my opinion, it's absurd to suggest that that is evidence that she would be flight risk. With that, Your Honor, we would ask for a reasonable appellate bond. We would specifically request an appellate bond that reflects that she is indigent. If the court is inclined to give a bond that's too high, it's tantamount to having no bond at all. And we would request that the court place her back on house arrest, pending her appeal with the same or similar conditions. Thank you, Your Honor.
Your Honor, this is Brian Claypool. I just have one final comment. I appreciate the opportunity. Actions speak louder than words. The past 8+ years of Dalia Dippolito on house arrest is the most powerful fact that we can show the court to warrant the court granting bonds. Contrary to what Mr. Williams said, if you agree with his theory, then Dalia Dippolito would have fled the country 7.5 years ago when she was on house arrest. She has 8 years of showing Your Honor that she does respect, putting aside all the evidence of the trial, she does respect the legal system. She hasn't flighted anything in the 8 years she was on house arrest. And certainly, it's much easier for somebody to flee from their home than try to flee from a prison using a drone. So I'm asking the court, please, take into consideration Ms. Dippolito's behavior on house arrest over the past 8 years. Thank you for your time, Your Honor.
All right. Probably disappointing to all, I'm going to take this under advisement. I have not granted or denied a request for an appellate bond after trial without writing a written order explaining my reasonings. And so I intend to do that in this case, no matter which way I go. I'm going to write a written order explaining my actions. So I will take this under advisement. I will issue an order. It will be timely. I won't wait long to issue it. I know everyone wants to know, particularly Ms. Dippolito, my ruling on this, but it will be in the form of a written order. With that said, we're in recess.